Professor of Law at Seton Hall Law School. I work on academic and practical projects related to sanctions, and I'm delighted to welcome 4 distinguished practitioners to this Hot Topics session on economic sanctions. At my left is from the Treasury, Daniel Glazer. He's Assistant Secretary for Terrorist Financing in the Office of Terrorism and Financial Intelligence. From the UN, we have Justyna Godzowska, a lawyer with the UN's Al-Qaeda monitoring team. To her left, Catherine Shepard from the European Commission, who's a lawyer in the Service for Foreign Policy Instruments. And at the end of the table is David Stetson from Goldman Sachs. He is co-head of the firm's government sanctions group. Now, it's interesting because Justyna and David have both worked together at Treasury with Danny in a prior life. Justyna and Catherine now work together across the table. So I think we're going to have a really interesting discussion today about the interplay between autonomous sanctions bodies and the UN, the role of the UN. Now, this is going to be a roundtable format. I will pose questions to the panelists, and I have encouraged the panelists to respond to one another as well, so I hope this will be an engaged conversation. And then we'll open it up to the general audience for a conversation. Before we begin, however, I'd like to just make a few observations about sanctions. Now, sanctions are a way for the Security Council and autonomous actors like the US and the EU to take measures that fall somewhere between statements and soldiers, it's sometimes said. They're a highly decentralized form of power. They stand in contrast to organized military intervention, but their volume and sophistication makes them extremely interesting. And in the UN context, at least, it's very interesting that the word sanctions is not mentioned anywhere in the UN Charter. Now, although the decision to impose sanctions has always been a question of political will and circumstances, there's an increasingly important overlay of law on sanctions. And so what I want to do just to start this conversation today is to mention 5 different ways in which I think law is increasingly being applied to these diplomatic tools. And these will be triggers for sanctions, the individualization of sanctions, the formalization of sanctions, effectiveness in sanctions, and then interplay. So let me begin with the triggers of sanctions. Now, as a general matter, sanctions are triggered by 2 broad sets of issues. First, regional or national security concerns, including weapons of mass destruction and terrorism. And secondly, concerns about human rights, democracy, and the rule of law. Now, it's this second set in particular that I think, at least in UN practice, has become very interesting from a legal perspective, because the violation of human rights, the commission of international crimes, has started to become a trigger for the application of sanctions. Now, unilateral actors will sometimes add sanctions on. They implement UN sanctions and then they add their own above it. But after the sanctions are in place, the objectives of the regimes can evolve as subsequent measures are applied, and there too law becomes very important. Sanctions can be used to bolster peace agreements, to encourage compliance with democratic processes, and to address misappropriation, corruption, or to challenge political change. So the first way in which there's an overlay of law in this diplomatic tool has to do with triggers. The second way in which law is increasingly important to sanctions has to do with the individualization of sanctions, and by that I mean the practice of targeting. There has been a fundamental shift in the way bodies have applied sanctions in the last 15 years. They've moved from comprehensive sanctions to imposing measures on non-state actors like entities, individuals, elites, rebel groups. And in fact, at the UN in the last 15 years, all sanctions regimes have been targeted with the exception of the sanctions of Libya, and that had to do more with the composition of the Libyan state than it did about the form of sanctions to be applied. So the pivotal idea here is that there is an individualization of sanctions, and that comes from the focus on non-state actors. And the third way in which law interplays with sanctions has to do with formalization. And by formalization, I mean development of the standards to govern their use. And this has, in some senses, been a response to the process of individualization, because there's increasing resort to quasi-legal and legal standards in all phases of the sanctions regimes. The issue was brought to the fore by significant cases such as the Caddy case in the European system, but in parallel, institutionally, to the development of the Ombudsperson's Office, the fair process requirements, giving reasons, transparency, and so forth have been fundamental. And I hope many of you were able to hear Kimberly Prost's excellent presentation in the last panel on precisely these issues. So the third development then is the formalization of standards. Fourth, there's a much more sophisticated conversation today about what makes sanctions effective. It's no longer correct to say that sanctions never work. It's no longer correct to say that all sanctions do is bring parties to the table. There's many more nuanced circumstances in which sanctions can make a difference. And the work of the Brown Institute, the Watson Institute, pardon me, at Brown, I think is central here in that it has tried to create 3 different criteria in which we think about the effectiveness of sanctions: signaling, constraining, and coercing. Coercing, really changing behavior, is actually the least effective way that sanctions are used, but there is a much higher degree of success with regards to signaling and constraining. And so there too, law has started to play in to the way that sanctions are applied. Now, the final comment I will make has to do with regime interplay. The UN currently has 16 sanctions regimes. The US government has almost twice that, at 28, and the EU tops the list at 37. These figures tell us 2 things. First, that there is important interplay between the regimes. When the UN passes sanctions, it is a legal obligation for the EU, the US to implement those. But as I suggested earlier, usually the UN sanctions constitute the floor. When autonomous actors implement sanctions, they often add on, and they often create the ceiling. So I hope one thing that the panelists will give examples of are the differences between the UN sanctions and the often much higher sanctions that are placed by unilateral actions. Now, a second observation is that over half of the current EU and sanctions regimes have no UN equivalent, and the most newsworthy regime in this regard, of course, is sanctions against Russia over the situation in Ukraine. So one question that we can consider throughout is, can sanctions be effective without the UN? So with that, let me begin the questions and ask the panelists, first of all, about this question of targeted sanctions. Without question, the field of sanctions has changed considerably by this move from comprehensive to targeted sanctions. But the practice of targeting actually differs considerably amongst the regimes that are represented here today. So my first question for the speakers is, what do we mean by targeted sanctions today?
Thank you, Kristen, and thank you all for being here. When first time I started thinking about sanctions was in a second-year law school class, an international business transaction class, when a prominent international practitioner came to speak to us, and he spoke about sanctions, and the example, he didn't think sanctions worked. And the example he gave was, if there is one sandwich left in a country, inevitably the bad dictator is the one that's going to eat it. Meaning that, the people you're targeting are always going to find a way around the sanctions, and it's the average person on the street that will suffer. I don't agree with them. Like Kristen said, I think sanctions do work. And as Kristen said, there has been a move away in the past 15 years towards targeted, also called smart sanctions, away from these very comprehensive country-based embargoes. The sanctions programs at the UN I work on, which are against the associates of Al-Qaeda and as well as certain associates of the Taliban, they've been around for 15 years, and they were one of the first kind of targeted non-state actor sanctions programs at the UN. When I think of the kind of quintessential targeted sanctions program, I think of the list-based sanctions, which means someone is listed on a list and designated, and therefore sanctions apply to them, be it financial sanctions, an asset freeze, or a travel ban, arms embargo. And as Kristen said, the UN has numerous, 16 such sanctions programs. But I think sanctions can also be targeted even more to really try to get the actors, the ones whose activity we're trying to stop, and really honing in on the activities that can hurt them the most. ISIL or ISIS, I realize that when I say ISIL, sometimes people think I say ASIL, so I'm not talking about ASIL, I'm talking about ISIL. Is obviously a big concern to the international community. And recently in a report, we kind of mapped out the financial streams of ISIL and recommended some sanctions or some activities specifically targeting those financial streams, because that's how you can really hurt the group. By cutting off its finances, as well as maybe make people that are willing to engage in business with them think twice. So a recent resolution from February, Security Council resolution, actually targeted the oil revenue of ISIL as well as the antiquity smuggling that ISIL engages in by encouraging member states to to propose for designation to the UN persons that are, the oil smugglers engaging in this trade with ISIL or those facilitating the oil trade for ISIL. And also, they imposed a trading ban, a cross-border trading ban on antiquities illegally coming from Syria after a certain time, thereby it's not a list-based program, but thereby targeting a specific commodity. I think targeted sanctions don't have to necessarily target individuals or entities. They can also target commodities. And of course, sanctions by itself are not going to necessarily eliminate all of the nefarious activity or the activity that it's going to stop. But the point is to make it disrupt such activity, to make it harder, to increase the costs to a terrorist group of doing business so that they have less money to engage in their terrorist acts. I pass it on.
Yeah, thanks. So the question is, what's the definition of targeted sanctions? I think that part is pretty easy. As Justina said, targeted sanctions represent an evolution over the past really 2 decades from countrywide trade embargoes to efforts to make them more targeted on individuals or entities, and in so doing, the theory being have less collateral damage, less of an impact on individuals or groups that we don't want to punish. The question, so that's I mean, I think that's pretty straightforward. I think the question though is, as Justina said, that the term smart sanctions, which is a term I really don't like, has tended to be made synonymous with the use of targeted sanctions, and I don't think that's necessarily the case. I think smart sanctions or a smart strategy of applying financial pressure on a particular target involves trying to understand the vulnerabilities of that target, trying to understand the collection of tools that we as a government or we as an international community have at our disposal, and then designing a strategy, as I said, of financial pressure that will maximize its impact on the target. And that's going to include targeted sanctions as they're commonly understood, but it may include a lot of other things as well. I think there's other interesting distinctions that could be made between targeted sanctions rather than just targeted sanctions and sort of trade embargoes. I think when you look at recent evolution today, you see evolution, you see a lot of discussion, particularly within the European Union context, frankly, given the legal challenges that they faced, between conduct-based measures and status-based measures. I think that's a direction that sort of sanctions practice and sanctions theory, if you will, is moving into. Previously, targeted sanctions referred almost exclusively to conduct-based measures, but that's not necessarily the case. You can have status-based targeted measures, and those, ironically, those status-based measures in some ways might be easier to defend in court, certainly in European courts, because there's less of an evidentiary issue involved in establishing someone's status than it is in establishing conduct, which is often grounded in intelligence that's difficult to share and sometimes a little bit murkier than people would like it to be. So if you want to know what I think of smart sanctions, I think you look at our the Russia program, our Russia sanctions that the U.S. and that the European Union have adopted, which is pretty radical in how different it is from previous sanctions programs. So you do have a targeted conduct-based sanctions component to our Russia program, but you also have a targeted status-based component to our Russia program, and then you also have some highly sophisticated and sort of custom design measures going after ability of particular institutions to sell equity, things like that, which is a reflection, again, of trying to understand what our leverage is and using that leverage. And that's the final thing I'll say, again, going to the question of, quote unquote, do sanctions work? think you have to ask yourselves, but it's a difficult question to answer because the question is, what does sanctions work? What does that sanctions work actually mean? And I think that we sometimes blur issues when we talk about do sanctions work. There are certain sanctions programs, say our counterterrorism programs, our counter-terrorist financing, counter-terrorist sanctions, or counter-WMD programs, which by definition are very conduct-based. And the purpose of those is to interfere with people's ability to do bad things. And that's very different from sanctions programs, the purpose of which is to develop leverage, to use the word that Kristen used, to coerce or to pressure countries to come to the negotiating table or to reverse a particular course of action that they've undertaken. Those are very different goals, and actually, I think that sanctions have proven more effective in the latter. I think that we could point to any number of issues, places where sanctions have developed a tremendous amount of leverage with respect to their targets. I think it's a separate question whether that leverage is always used the right way. But I think we have a very good track record of creating leverage. Where it becomes very difficult is sanctions as actually disrupting specific activity. That's what gets very hard.
Great. Okay, let's go over to Catherine and David for their view on what targeted sanctions mean today.
Thanks, Kristen. Well, I certainly agree with a lot of the comments of Justina and Danny on this. And it's true that in the EU, we have faced quite a few challenges in terms of giving effect to targeted sanctions, most of which have traditionally been very much behaviour-based or conduct-based. And part of our problem has been adducing sufficient information to satisfy the court that the reasons for the listing are based on sufficiently solid information. And we've time and again come unstuck in the court because we haven't been able to produce sufficient information. But there's a line of authority that's emerging from the ECJ now, particularly in the context of Syria, that suggests that we could perhaps restructure some of our targeted or behaviour-based sanctions. So instead of relying so much on conduct, we can start looking at status-based listings. And the court has recognised that in certain contexts, if you have the right factual background and context, a presumption may come into play that certain categories of persons with a particular status benefit from the regime and support the regime. And some of those categories of individuals that have been recognised in the Syrian context include not only the leaders of the regime and family members, but military leaders and leading businessmen. And the good thing, I think, about beginning to restructure some of our conduct-based or behaviour-based sanctions to put them more into a status-based framework is that what we hope to do is shift an evidential burden from the designating authority to the listed person. So if they fall within, if we can prove that they are of a particular status, the court has said that in certain circumstances, it would then be over to that person to displace the presumption that they were supporting the regime. And that can be very helpful to us because we've struggled on occasion to have sufficient information to support the conduct-based listings.
This is probably the point on which I have the least to say, only because in the industry perspective, we essentially sit outside the black box and wait for the lists to be updated, wait for the names to come out, and then obviously do whatever it takes to comply with the list, both in terms of ensuring that they aren't among current customer base, as well as ensuring on a going forward basis that they don't become a customer or a client. One thing I have noted, though, in the context of the distinction between a conduct-based and a status-based sanction is that status-based sanctions have the potential to be more impactful, at least from a private sector compliance perspective. And the reason for that is that the types of activities that can lead to satisfying a listing criterion for a conduct-based sanction are also the kinds of activities that would be red flags in a customer due diligence or a know your customer process at the time that someone is seeking to start up a relationship with a financial institution. And I should also say I'm speaking sort of broadly with respect to the sector rather than, of course, to any particular institution, including my own. But what that means is that it's less likely that someone who satisfies the criterion for, say, a terrorism listing to have made it through the customer due diligence process at a U.S. financial institution, when, on the other hand, the criterion for listing is simply whether you are Vladimir Putin's judo partner. That fact certainly would have been identified as part of a political exposure analysis when that customer was being considered, but it wouldn't necessarily have precluded the formation of that customer relationship. So a status-based sanction has the potential to reach into categories of sanctions targets that are more likely to have exposure and interplay in the U.S. financial system.
Great, thank you. So let's move on to the question of coordination between the UN and then regional or domestic sanctions bodies. Can you please tell us, how does it work? How can it be improved? And perhaps you can give reference to the process of proposing new designations and also giving effect to those designations.
I can start on this one as well. So cooperation and coordination for the UN with member states and also regional organizations is crucial, obviously, to the implementation of sanctions. When a UN passes a sanction, when the Security Council passes a sanctions under Chapter 7, all 193 member states of the UN need to implement it. So talking to them, making sure they're aware of the sanctions, if there are any issues, that kind of cooperation and coordination is essential. But also on the designation side, the way the regimes I work on work, and that's not necessarily true for all UN sanctions regime, is that any member state can propose a listing to the committee. The committee makes a decision by consensus, and the committee is made up of the representatives of the 15 member states on the Security Council. So any member state can propose a designation, including supporting documentation why the person meets the relevant criteria. So kind of that coordination and cooperation is crucial to have designations come through. And it's also, counterterrorism is terrorism is a global problem. Therefore, it's very important to have buy-in and ownership of the regime from as many member states as possible, ideally all of them. And I think in the designation process, there's definitely room for more member states to be involved in proposing designations to the Security Council, to the committee that works with the Security Council.
Catherine.
So I'll probably tackle this more from the point of view of the implementation phase and the coordination that we need to have to support listings before the courts in Europe. The reason that I'm focusing on that is that the EU competent authority that defends the listings in court is not actually usually or ever the designating state or entity. So when we go to court to defend listings, we're relying very much on information that is provided to us in the AQ context, very much information provided to us by the UN. So when we first list a person, we implement a listing from the UN, we are providing that person with the summary of reasons that's provided to us by the Sanctions Committee. And in a recent case of Mr. Yusuf, we have provided Mr. Yusuf with a summary of reasons that was provided to us by the Ombudsman. So we were delighted with that because it gave us a much more solid sort of factual matrix that we could, that underpinned our listing process in the EU. So this, in fact, is actually one of the big implementation challenges for us. And we want to go about building better information sharing networks with designating states at UN level, so that when we come to implementing the listing in the EU, we actually have information in our back pocket that we can use to show the court that the listing was made on a sufficiently solid factual basis. So I would see the proper coordination between the EU and the UN as absolutely critical in that regard. I would also say that it's a topical issue at the moment for FATF in looking at how quickly we can give effect to listings, and I'm not sure, perhaps we'll come on to that later in the session.
Danny, did you want to comment on coordination?
Sure. I mean, it seems like a pretty straightforward question, but it actually sort of raises these sort of metaphysical issues as to what exactly is the United Nations. Is the United Nations a body in which countries coordinate with each other? If one were to think of it that way, then then that leads one to think about coordination with the UN in a different way. You're cooperating with the other countries seated around the table, and it's important in any multilateral context to do that. Or is the UN have some sort of is the UN somehow an independent actor that needs to be coordinated with? And I think the answer is somewhere in between. I'm just sort of presenting two extremes there. So I think it's right. I think it was Justina who made the point that you could come at this. You could come at the question of coordination. You could break it into two separate categories: coordination with respect to targeting and designations, on the one hand, and then coordinating with respect to implementation. On the other hand, I mean, with respect to targeting and designations, coordination really becomes information sharing. I mean, that's what the coordination is: making sure that you provide enough information to the decision makers, whether they're within the UN itself or within the member states, that they feel comfortable moving forward with a particular designation. After you do that, providing Kim Prust with enough information so that she could do the right thing and say that it was a righteous action. And there's all sorts of very, very difficult and complicated questions that go along with that Kim and I have spent many hours debating with each other. But they're all really interesting questions. And again, get to some, I think, pretty interesting legal issues involving standards of proof, and again, what exactly is the role of the United Nations in this, and domestic law versus international law, and all sorts of questions about classified information within our system. And it's really important from a U.S. perspective because, as has been said, while everybody's encouraged to make nominations, the fact of the matter is the lion's share of this is coming from the United States, and to the extent that it's based on intelligence, a lot of it, it's coming from us. So all these issues are really, really important to us. And it's important that we have a good relationship and good coordination with Kim and also, of course, the other members of the Security Council. The second is, and actually what I think is, what I focus on more, and where I think there's less thought put into it, is implementation. The fact of the matter is that there really isn't an enforcement mechanism for the UN Security Council. Their Chapter 7 resolutions need to be implemented as a matter of international law, but there's really, within that assertion, there's a huge range of compliance with it, and I would say that most countries in the world do not have effective implementation mechanisms for targeted sanctions. It's just not something that they've either prioritized or have the capability or the willingness to do. And that's something that I certainly spend a lot of time on in my bilateral engagements with countries around the world, is to understand how they implement sanctions and to try to provide support and help in making sure that they have effective sanctions implementation regime. Both Justina and David used to work at OFAC. There's not a lot of countries in the world that have an OFAC. Frankly, there's probably no country in the world that has an OFAC other than the United States. And I think the existence of OFAC shows that we prioritize implementation of our sanctions in a way that's not often that you don't often see, and that's something I think that's important.
Thanks a lot. David, any perspectives from an industry?
Just, I think, maybe just say something that's probably implicit or obvious to many folks in the room, but from a compliance perspective, when looking at the possibility for coordination among listings, the safest thing to do, and what most institutions tend to do, is just adopt a greatest common denominator approach to looking at the various sanctions regimes that apply in the various places they do business. So, if there's an individual that's listed in the EU but not in the US or vice versa, as a practical matter, most institutions that are operating globally will simply treat those the same as an individual or entity that's listed in both places.
Thanks. Okay, let's turn to Iran. On April the 2nd, a joint plan of action was announced with Iran, and as everybody knows, one of the central components of the deal was to trade sanctions relief or a promise not to build a bomb. I don't think it's controversial to say that sanctions were one of the things that brought Iran to the negotiating table, but what is being discussed is what happens now. There's been a lot of differences of opinions about whether or not the sanctions are being suspended, whether they'll be lifted, and what the timetable will be for that. So let me ask the panelists, what's going to happen? Which of the different layers of sanctions might be eased first? What would it take for U.S. industry to start investing in Iran?
I'll maybe take a first stab at this. I think I'm in a fortunate position here because I understand the Iran framework very well, and yet have been out of government for long enough that I have absolutely no insight into the current negotiations, so there's no risk that I'll let slip something that is not supposed to be let slip. I think it's useful to look at it through the framework of, as Kristen said, the various layers of sanctions that exist with respect to Iran. And at the risk of oversimplifying a bit, there are essentially four big categories. There's the comprehensive US embargo that was put in place in 1995. There's sanctions on specific individuals and entities in Iran under the WMD proliferation sanctions that OFAC administers. There's additional sanctions under the counterterrorism authority that OFAC administers. Again, various Iranian individuals and entities listed there. And then there is the fourth category of the secondary sanctions, which are the triggers for potential sanctions against third country entities based on certain dealings with Iran. For example, banks that deal with designated Iranian banks, or oil sector entities that work with the Iranian oil and gas sector, for example. So looking at all four of those categories, and then looking at the discussions that have been happening recently with respect to potential sanctions relief under the JCPOA, the thing that jumped out, I think, at many of us in the fact sheet that came out was the notion that nuclear-related sanctions would be eased after verification of certain key steps that Iran had taken under the agreement. And it's not clear. Only one of those four categories that I was describing is clearly nuclear related. And so it's possible that even if that category of sanctions does have some significant easing after a joint plan of action, a comprehensive negotiation is reached at the end of June, it's still possible that a lot of the framework could remain in place. So that's, I think, an area that will need to be fleshed out during the remaining negotiations, and then obviously publicized so that the compliance community and the private sector can know what has become in bounds and what remains out of bounds.
I actually just have a question for David, because I noticed that in the US fact sheet on Iran, there was the possibility of snapback. That is, if Iran were somehow not to comply with the agreement, then the possibility would be that all the sanctions would then immediately spring back into force. And I was just wondering how that would be seen from a sort of industry perspective. Like, would that create conditions in which it would be possible for companies to start up business in Iran?
It's a very good question, and I think the parallel that springs to mind immediately, although it's not a very good parallel, is the lifting of the sanctions against Burma or Myanmar in July of 2012, which were done largely through a general license that Treasury issued. And the nature of a general license is that it can be amended or revoked at any time, and so it does raise the question of just how much one that is looking to invest in Burma or in the future in Iran, if there's a similar general license, just how much one is willing to put at risk when there's always the possibility that that general license could be revoked in some type of snapback scenario. I don't have good stats on what has happened with respect to Burma, but I would say I would expect the private sector actually to be very cautious and really that it would just because of the lingering uncertainty until there were a solid track record of Iranian compliance that made the likelihood of a snapback quite low. I would expect people to be quite tentative in going into that market, even though it has a lot of attractiveness.
No, I don't really have much to add to that. Obviously, any final comprehensive agreement is going to involve a substantial amount of sanctions relief, but there's a lot of negotiations left, and there's a lot to talk about, and that's just going to have to be hammered out over the course of the next several months.
So if Iran is an example of interaction between sanctions regime, the sanctions that the EU and the US have applied against Russia over Crimea and Ukraine is an obvious example of the opposite. For clear reasons, there were no UN sanctions on Russia. So my question to the panel now is, what's the effect of not having sanctions against Russia? David.
I would say, somewhat back to my earlier comment with respect to the greatest common denominator, I think certainly for a U.S. institution and really for any global institution, to have the U.S. and the EU both acting really in closer concert than we've seen in any other sanctions regime has, from a compliance perspective, made it not all that different from if there were a UN regime in place, in the sense that we look to the prohibitions that are articulated under the U.S. regime and those that are articulated under the EU regime, and there actually has been a substantial amount of effort that is evident even from outside the black box between the U.S. and EU authorities to really bring both their prohibitions and their interpretations into line with one another. And so the absence of a UN program in that context has not been terribly impactful from the private sector perspective.
Yeah, I mean, again, I think Russia's a perfect example of how sanctions can be effective outside of a UN context, and again, why I always resist using the term smart sanctions as synonymous with targeted measures, targeted conduct-based sanctions. If we could wave a magic wand and have there be a UN sanctions program with respect to Russia and Ukraine, and have a few names on a list of individuals, say, who were involved with Crimea, I don't know how impactful or quote unquote smart that would be. What you see with the Russia sanctions programs, both in the United States and in the European Union, is an attempt to look at a target, understand what that target's vulnerabilities are, and then devise a program of financial pressure that could create leverage. And that involves understanding what the vulnerabilities are and what we have that's valuable that can be taken away and is not replaceable, not easily backfilled in other places. Access to European and American capital markets and financial markets is something that we have that is not easily replaceable. There's a reason why people like to do business in Frankfurt and London and New York. There's a reason they like to do that. And it's not so easy to replace the services that those financial centers provide. And as you can see, as a result of the sanctions programs that have been implemented, it has had a substantial impact on the Russian economy. Of course, drop in the price of oil has only reinforced that. But so would it, if you could take that package of measures that we've adopted and transpose that into a UN Security Council resolution, of course it would be more impactful. By definition, the more multilateral a program becomes, the more effective it's going to be, by definition. But I think it's apparent that you could have an impactful sanctions program without it being global in nature.
Catherine, can you give us the EU perspective?
Well, I guess that I can see that in many ways you like, when you can, to operate in a UN context. You like to act under Chapter 7 of the Charter. because this gives you much wider buy-in and, from some perspectives, perhaps even greater legitimacy. But perhaps in this case, I mean, obviously we were never going to get any UN measures through. So perhaps what we lost in terms of wider buy-in and legitimacy, in a sense, you gain in flexibility. So it means that those who are constructing the sanctions package are a tighter subgroup of actors, and they're the ones that are deciding the balance of cost and burden. And there was quite a discussion, I think, when that sanctions package was put together about burden sharing. So that was one of the preoccupations, I think, certainly in the EU, was how the costs of that sanctions package would be shared across Europe and together with other partners. So I think that, yeah, we like to operate when we can within a UN context, but in this case, we were able to achieve what we needed to achieve, acting autonomously together with other partners. And I think it's also sort of timely to point out that sometimes with sanctions, we're not always looking to achieve concrete effects. We're also trying to achieve certain kind of signalling. And that was really important with this set of sanctions measures. We were signalling that we objected to the illegal annexation of Crimea. And in a sense, to that extent, it was almost less material precisely what went into that sanctions package. We needed to do something. And so those are my reflections on that.
Can I add to that? Because I think that last point, the signaling point, is a really important point. And not only did it signal what Catherine suggested, but it also signaled that the European Union countries together and the European Union and the United States were standing together in sending this message. And I think a lot of people thought that that wouldn't be the case. I think a lot of people thought that there would be big divisions within Europe, and then there would be divisions between Europe and the United States on this issue. And the fact that we've been able to put a very tough sanctions package together and do it as allies and do it cooperatively and do it in unison has sent the loudest and strongest message of all.
I think it's also quite striking, and it just occurred to me sitting here, that to contrast the way that the Russia-Ukraine regime has evolved, the sanctions regime has evolved with, say, the way, again, the Iran regime evolved, which was started off as a very unilateral U.S. program, and then really the way that the U.S. Managed to expand its leverage beyond U.S. persons that are directly bound by U.S. jurisdiction to third country entities was through this regime of secondary sanctions, which has a spotty track record going back to Helms-Burton. But to contrast that approach to the approach of getting a core set of common ground between Europe and the United States at the outset of the program, so that it doesn't turn into the U.S. trying to essentially extraterritorialize what began as a unilateral program.
Great, thanks. So let's move on to a couple of questions with regards to compliance. Given that there are often multiple sanctions measures that will apply to the same situation, how do states clarify, how does the private sector clarify what their obligations are? If you could comment on what agencies can do to better streamline information in particular, that would be great.
I can take a stab at this one. I think there are a couple of significant ways, I think, both formal and informal. On the formal side, there is a practice of, there used to be more of a practice of issuing redacted guidance letters that would be published online or in the Federal Register in the old days. That would describe, in general terms, the guidance, the interpretive guidance that was given to a particular party that had asked a particular interpretive question. That has largely been supplanted by frequently asked questions. I'm always amused when frequently asked questions are issued on the same day that an action is taken, because I don't know how it just met, again, angels on the head of a pin. I don't know how it can be frequently asked if the action hasn't actually occurred yet or is occurring concurrently. But FAQs, I think, even if it's a misnomer, are still designed to anticipate what the most likely questions are going to be, and then to answer them, to provide the guidance to the regulator community. And then the third is the one that is sort of most difficult, which is the essential interpretation by enforcement, and that is the nuggets of interpretive clarity that go into a description of a penalty settlement or an enforcement action that can, help those who are looking for more clarity on how the rules are actually interpreted can help to provide that guidance.
This question brings to mind me like de-risking, which is a word I hate, and much has been written about it lately. And it's often thought about in the AML-CFT context, although it doesn't necessarily pertain to that. But I think when we spoke to industry about it, what they've said most likely is that when we asked why are you cutting off these business lines, because in our view, financial inclusion is important. It's very important not to drive people into a less regulated channel, because then you have much less visibility into what they're doing. So what we've heard most often is clearer guidance, that they are just confused about the overlay of various regulations, and EU, US, and it's, and maybe taking the lowest common or the highest common denominator, whatever approach makes sense from a cost perspective, but it also tends to maybe have unintended consequences that it drives people to use less regulated channels.
Yeah, I actually think that this is a very good question, because what I've been really struck by in my work on sanctions is how much ambiguity or uncertainty we have, even when it comes to really, to my mind, quite sort of basic fundamental concepts. So, for example, making economic resources available, that's prohibited across the board when it comes to UN sanctions when you have an asset freeze in place. But there is a lot of debate about what that really means, and there's no consensus on that. So, for example, one debate that I've had with a lot of colleagues is, does it include services? So if you've listed an entity, a business entity, can you still provide utility services to that entity? Can you provide cleaning services to that entity? Should you provide internet services to that business? Effectively, can you keep the lights on? That is kind of the question. And yes, the AQ monitoring team have faithfully produced some, I think, very good guidance on some of these concepts. And I can have my own personal view, but what I'm really struck by is just how much lack of consensus there is around these things. And then you have to go back to questions around what the purpose of a sanctions regime is. We don't apply sanctions in order to take those assets away. So when you're talking about a business entity, you don't want to apply sanctions measures in a way that they become bankrupt. That would seem to go contrary to the notion that the full properties should be restored to the listed person or entity when that measure is lifted. So perhaps there has to be some kind of balancing exercise so that business can continue to potter along and survive pending the lifting of those measures. So I'm struck that we need to have more discussion on some of those basic things.
I don't know how to respond to that last thought. If a business has been designated for providing material support to Al-Qaeda, I'm not that worried if the business goes bankrupt. I think it's important that we do our best to be as clear as possible. And David ran through some of the ways that we as governments try to do that. This gets back to the point I made before about governments having an OFAC or some sort of OFAC equivalent. OFAC's responsibility is to implement U.S. sanctions programs, and an important part of that responsibility is communicating with the private sector and providing as much clarity as possible, whether it's through an FAQ or through direct dialogue and communication. And that's something that we at the Treasury Department, not just OFAC, but the Treasury Department at large, are very committed to and frankly devote quite a lot of resources to, is making sure that we retain a very vibrant dialogue with the private sector, whether, again, it's through OFAC, whether it's through blogs, whether it's through conferences. We have, in a number of cases, something called a public-private partnership dialogue with various jurisdictions. With Mexico is a good example of that, and there's other jurisdictions and regions that we do that with, all to make sure that there's maximum dialogue and understanding. As far as clarifying international standards, that's also important, and there's a variety of places where that could be done. One of the most important places where that is done is in the Financial Action Task Force, and I know that was referenced earlier, but the Financial Action Task Force is a good forum for real financial experts, government financial experts, to sit down and try to hash through some of the issues associated with it. So, it is an important issue. It's something that I think everybody acknowledges is an important issue, and something that we try very hard to be as responsive to as possible.
I wanted to respond to something what Catherine said, and maybe it's because I used to work at OFAC that I also kind of maybe disagree partially with her in that it's, we, as the monitoring team, we travel all over the world and we speak to various countries, and as Danny has said, the level of implementation of the sanctions varies dramatically, but one of the questions we always get asked is, when someone an asset freeze applies, it applies to all of the person's assets, whether they're used for terrorism or not, and often the question I get is, we're just providing bricks, or we're not providing bombs to these terrorists, we're just providing this good. But the way I always explain it is like, okay, well now they have more money to buy bombs because they don't have to buy the bricks or whatever. So that's always, how I think money is fungible, goods are fungible, they can be sold. So I think you have to keep that in mind as well.
I just, for the record, would like to say that I actually really agree that certainly I think that, to my mind, it's beyond doubt that provision of services to a listed entity is within the scope of making economic resources available, certainly for the AQ regime. But I think some of the most interesting discussions I've had recently within a European context is whether you can read across that logic to third country regimes. I don't know whether, Justina, you feel you could comment on that, but...
Yeah, well, each regime is different. I cannot speak about the other ones. I think we may be the only one that has these explanation of terms papers that explain these. Others do not, so I wouldn't want to comment on how they may interpret it.
Great. This conversation reminds me of one of the famous unclarities in the UN context was the sanctions against the DPRK, in which luxury goods were banned, but there was no definition of luxury goods until a clarification came out several years later, so it falls in with this. Okay, the temptation is strong to apply sanctions, and so my next question has to do with whether or not we are reaching too readily for sanctions as a policy tool. Does the United Nations, does the EU, does the US balance the burdens of compliance with the policy goals of applying sanctions?
I can take a first stab at this one. I think it probably is simpler in the unilateral context than in the multilateral context to reach for sanctions as the tool. And we have seen, I think, in the list-based sanctions context in particular, a pretty marked evolution just in the past 3 to 5 years, I would say, of the types of things that sanctions are being deployed against, and getting sort of farther and farther afield from what the core conception of what sanctions were for used to be. One example would be the cyber EO that was just executive order that was just released a week or two ago in the U.S. But there's also discussions on the political side in the U.S. around using sanctions to target corruption anywhere in the world, to target human rights violations anywhere in the world. There's a U.S. sanctions program that is named for Sergei Magnitsky, who's an individual who, very tragic story, was imprisoned in Russia on widely believed to be trumped-up charges and died in prison. And a sanctions program was created in order to freeze the assets of those who, in Russia, who were involved in his incarceration and his death. And that has led to this now a notion that if we're going to do it for Sergei Magnitsky, why not do it for those types of violations wherever they occur anywhere in the world? And I think it becomes a question both of whether the resources of the sanctions implementation authorities are up to the task, both of finding the right targets to designate, as well as administering the program once it's up and running. And then it also becomes a question of whether the burdens that a new program creates are commensurate with the benefits of having that sanctions program in place. When there's a name that goes on a sanctions list, there's an enormous compliance apparatus that gets kicked into gear. And if it's a name that is fairly common, then it could actually generate an enormous amount of friction while various private sector entities have to figure out whether they are or are not dealing with the person that's been added to the sanctions list.
I often get kind of the question, you're putting this hardcore terrorist on the list. That guy is never gonna go, try to open up a bank account in his name. He's probably never gonna try get on the plane. What's the point? I think there is a point. I think we discussed before, it's an important signaling point that the UN especially has, saying that this person is a threat to international peace and security. Therefore, 193 member states should implement sanctions against them. I think this is the worst of the worst. And I think you need to have the Osama bin Ladens on the sanctions list, whether they will or will not ever open a bank account or try to transfer money in their name. That said, I've found sanctions perhaps are more effective in places where it's a person that has one foot in the legitimate world and one foot kind of in the illicit activity. For example, the rich businessman that also does a little bit of terrorist financing on the side, or the oil smuggler for ISIL that also engages in other business. I found both in the US government and at the UN, those are the people that are coming in and seeking to be delisted through the various avenues available to them. So to me, that means that sanctions are having some effect on their life. That said, Al-Nusra Front, which is one of the terrorist organizations operating in Syria, Al-Qaeda affiliate, when they kidnapped UN peacekeepers in the Golan Heights last year, one of their demands for the release of the peacekeepers was to get off UN sanctions list. So I think clearly the sanctions even, obviously that demand was not honored, but clearly sanctions do even affect groups like the Al-Nusra Front. But what we do have to keep in mind unintended consequences. And in a recent resolution, the one I had mentioned before, the Security Council actually, at the recommendation of the monitoring team, tasked the monitoring team with doing an impact assessment of the new measures that the resolution imposed, looking at the effectiveness, but also at unintended consequences. To see whether adjustments need to be made. So I think that's an important provision, having the security recognize that sanctions can have unintended consequences.
Great, thanks. So two themes that I hear that I think are quite interesting here are overcompliance, that comes up with our last conversation, and these unintended consequences of sanctions as well too. Catherine or Danny, did you want to weigh in on this question of the pros and cons, the policy benefits or burdens of applying sanctions?
Well, I guess that I think that my impression is, working in the European Commission, we do have a role in advising the private sector in relation to their sanctions obligations. And what I'm really struck by in that work is just how conscientious many banks and financial institutions in particular are, in terms they take their sanctions obligations really seriously. And we rely on them in making the right judgment calls. So when we talk about enforceability, they are very often in the front line making decisions about how the sanctions measures should be applied. So we rely on them to get that right. What I worry about more, in a way, is the smaller operators, the ones that are less sensitised to what their responsibilities are. And I think, speaking more from a European perspective, perhaps we need to do more to reach out to them, to build awareness of sanctions and how that should impact on their behaviour. And I also think we have a lot to learn from the private sector as well. We need to make sure that sanctions are framed in a way that speak their language, so that they're readily comprehensible by the people that have to apply them. And I think that more should be done as well to look at the implications for business, to do a more sort of systematic study of the burdens of compliance, so that we can then feed that back into the way that we frame measures and make them more targeted and effective in future. We actually have information sharing provisions in all of our EU legal acts, and it requires economic operators and member states to share information relevant to compliance. And we're trying to develop that so that there's a more systematic feeding back of information, so that we can basically improve measures. Thanks.
Yeah, look, I'm not really sure what the term overcompliance means. I think there's a sense out there that, say, we in the Treasury Department have a knob somewhere, and if we're really mad at Iran that day, we could go from 7.2 to 8.9, and then if things get a little bit better, we could bring it down to 6.3. That's not how sanctions work. And so it's the idea that we're going to, we try to be as precise as possible. We try to be as responsive as possible. But at a certain point, there's limits to how much you can fine-tune things, and there's limits to how much you want to fine-tune things, because, as I think has been hinted at a number of times, these aren't press releases. These are actions that have impact on businesses, and businesses need to be able to have reasonable expectations that when they adjust their compliance program to deal with a particular sanctions program, that there will be some consistency with that sanctions program. So in certain ways, you don't want to go from 7.2 to 8.9 to 6.3 all in the space of a couple of months. There needs to be some level of consistency and a reasonable expectation of that consistency, and so I think that's important. That's important to keep in mind.
Just to pick up on the very good point that Catherine made, because I think we have actually seen, especially in the context of the Russia-Ukraine sanctions, a very publicly articulated sensitivity to trying as best as possible to calibrate the impact on the sanctions target and to maximize the impact on the sanctions target while minimizing the collateral impact that is, just the unintended friction that on both the EU and US institutions. And there's also a structural impediment to, I think, doing all that much more than has already been done, which is the authorities can't preview these measures with the industry before they're adopted. The classic formula in all of the U.S. executive orders that talks about why due process is not given to someone whose assets are about to be frozen is that it would undermine the effectiveness of the program if the person or the company was given notice and an opportunity to respond before they were put on the OFAC list. So I certainly think it would undermine that argument if regulators were previewing with the private sector what they were intending to do and getting a read on how would you carry out a restriction on new debt, or how would you carry out a restriction on new equity. And so that structural limitation is there. The sectoral sanctions, to me, reflect a salutary evolution towards the regulators trying to weigh those burdens and benefits as best as they can.
Just to clarify something, which I'm sure David agrees with, due process is given to people, sanctions targets, before they're designated. It's just a different level of process than they receive afterwards. But it is certainly the case that due process is afforded to them at every step along the sanctions life cycle.
I was speaking in terms of, the sort of formalities of notice and an opportunity to respond. That's right.
I just wanted to come back in here because just as another word in a way, from the perspective of the private sector, when we talk about over-compliance, it sounds like we're complaining that they're choosing not to take on transactions or activities which come with risk of illegality or reputational risk. And for my part, I find it really hard to be critical of the private sector when they choose to step back from high-risk activities. Because what we're doing in applying sanctions in many cases is we're radically destabilising the business operating environment. And we can't really be surprised if, for example, banks don't choose to set up correspondent banking relationships with banks in Syria if they're at risk of some kind of illegality. So that will have implications for us which hurt our sort of efforts in Syria in other ways. So, for example, we need still to run humanitarian assistance programs in Syria. We've had problems getting money into Syria. We've literally resorted to sending money across in suitcases, like literally cash in suitcases across the border. And that's because we can't get the transactions through banks. And we've looked at how we can address that as a problem. And one of the ways we've done it in the EU in a sort of tentative way is we've issued letters of comfort trying to explain the intended scope of the EU measures. We find it more difficult to explain the scope of US measures, but that's often just as much as a concern to the economic operator as the EU measure.
We expect banks, and let's take this out of the sanctions context or the AML-CFT context. We expect banks to manage risk. All governments around the world, certainly any place that has a sophisticated financial center. There's a generally accepted approach to financial oversight and supervision. There's generally accepted understanding of what we expect from our banks, and what we expect from our banks is to manage risk. And banks are very good at it. And they hire really, really smart people like David to help them with it, and they probably hire a lot of people sitting in this room, and they have compliance departments measured in the hundreds of people, if not thousands of people, to help them manage risk. And not just compliance departments, but risk management departments within the bank. And what we expect from the AML-CFT sanction side is for banks to understand their risks, and to manage those risks, and if they can't manage those risks, to not engage in that type of activity. This is like 101. This isn't new. This isn't controversial. This is bank regulation, bank supervision. And so what that boils down to for banks, by definition, is a cost-benefit analysis that they have to do to see whether they conclude that they could still make a profit without exposing themselves to too much risk, and and how they mitigate against that. And certainly, AML-CFT compliance or sanctions compliance is one of the factors that they look at. Banks still do business in very risky jurisdictions. There is not a lot of evidence that AML-CFT or sanctions compliance in a systemic way has driven banks away from risky jurisdictions. There are anecdotal incidences which are very serious and which we take very seriously, and for all the reasons that have been said before, we work very hard with industry on solutions. But the fact of the matter is that banks conduct cost-benefit analysis, and they act upon that analysis.
Okay, we're going to open it up for questions. David, do you want to respond to that, or?
I think I have nothing to add to that. Thanks.
Okay, great. All right, so we'll take 3 questions in succession and then invite the panelists.
Thank you very much. Peter Truboff. 2 quick comments. One on the question of Iranian sanctions and rollback. This may be the first case where we will actually have the other side, the sanctions side, have a rather interesting, I'd rather like to be a fly on the wall discussion of which sanctions they'd like to see go first. Because if you take David's 4 categories, you could imagine a rather robust discussion in Tehran over burden sharing and over which sanctions should go first, and presumably that will be part of the negotiation over the coming months. So it's a very different dynamic from some of the others we've seen, and we should watch that space because I think it's going to be very interesting. The second point I want to make is we talked about, and you talked about, due process and the effects of designation and the process for removal from designation. As one who's been involved in these cases, I must say there's one element that hasn't been mentioned, which is counsel on the outside for anybody who's been designated is in many respects trying to prove a negative. That's one of the hardest things in the world to do as a lawyer, because whether it's conduct-based or status-based, you sometimes are into this "it didn't happen" situation. Very hard. I don't at all question the good faith of those in government, but I think the burden of anyone trying to present evidence to get someone delisted is enormous because of the negative proof. Finally, a word of history. Dean Acheson was called back into the State Department on the eve of World War II, and one of the first things he did was to try write some of the first economic sanctions as we know them. And somewhere he is quoted as saying, I can never find the source, that we wrote them so that it would be difficult to find the lines. And I suggest that spirit is still around.
Yes, please. Yes, we'll take one from here and then one from this mic. Go ahead.
Hello, my name is Marcus Davies. I'm with the Canadian Department of Foreign Affairs and the Legal Affairs Bureau. And just for background, I've been our G8, G7 representative on asset recovery. A comment starting off, I'd note that Canada has also been at the lead in making sanctions. We have a very sophisticated sanctions program. Our law provides for a self-reporting mechanism that allows our banks to report to our law enforcement authorities. And but one point that was noted between asset freezes and sanctions, noting the point that asset freezes are often incorporated into sanctions, but are not necessarily part of a sanction framework because they can be for the purpose in the Ukraine context or in the Arab Spring context to simply freeze the assets and bring them back. But a common challenge that is faced, whether it's sanctions that are in using an asset freezers for punitive purposes or asset freeze measure just to freeze the assets to return them because they've been stolen through corruption, a common problem is that the beneficial ownership of that is an incredible challenge to trace the assets and follow it. So you can do a designated sanction, list an individual, list a financial entity, but if they create a shell company and they move through different jurisdictions that don't have strong beneficial ownership provisions, you're going to lose the link of it. And there is, in the G7 context, a lot of push to, especially within the UN Convention Against Corruption, to target this as a measure that needs to be the second wave of being effective in actually tracing assets and recovering them, or because it's very easy to lose them. So my question would be to the panel members is, to what extent do you see beneficial ownership as an important area in development to effectively implement sanctions so that you actually can trace and identify where assets are going and potentially return them? Thank you.
Thank you. Yes, please.
Thanks. I'm Scott Paul with Oxfam, and so we're seized with the issue of de-risking very, very deeply at the moment. And I promised myself I wasn't going to ask a question about this, but the conversation sort of naturally veered in that direction. So actually I had 2 related questions. The first is, completely agree with Assistant Secretary Glazer's assessment that it's not AML CFT regulation enforcement alone that's driving this, but it does seem to be a combination of that regulation and enforcement plus low profitability plus high risk, right? And so there seems to be a nexus of where particular product lines and particular parts of the customer base are getting cut off. And so I'm wondering, is there another side of the equation other than AML-CFT that might be ripe for intervention on profitability, for example? Is there a way to make these certain types of customers or certain types of product lines more attractive and more profitable, particularly when they're getting cut off from the formal financial system? Secondly is relating to one of those anecdotes that's coming up. And I won't go into the details of the issues of remittances to Somalia, but suffice to say it's in the news a great deal. And I'm wondering, to what extent are you each concerned that, rightly or wrongly, there's a narrative that's being built that the US government or the UK government is shutting down certain product lines like remittances to Somalia, and then that's having second-degree effects in low-capacity countries, which, even though they see FATF guidelines that say we like a risk-based approach, are saying, well, we're low capacity and we want to make a show of force. So, for example, like in Kenya, they're going to close down and just revoke licenses of Somali money transfer companies. To what extent is that a kind of knock-on effect that you're all concerned about?
Good, great. 3 questions, terrific questions for the panel. Danny, please.
I'm sorry, I should have been writing all of this down. With respect to, so I'll start with the question that is freshest in my mind. When someone asks me, am I concerned about this? It's hard to answer that question because I think one of the problems in the de-risking discussion generally has been that it exists at too high a level of abstraction. You know, I think de-risking means a lot of different things to a lot of different people, is used in a lot of different ways. And I think that a more productive discussion gets to the second point that you made, which is we need to, you know, de-risking might mean 10 different things. You know, maybe 7 of them aren't problematic, and then there's 3 things of them that are quite problematic. And I think it's important to get down to identify those 3 things. I mean 3 things, and have more specific discussions and more practical level discussions than sort of this endless cycle of highly generalized discussions. And certainly, the case of Somalia is a good example of that. I think that there's still a lot of information that needs to be collected to understand precisely the level of access that Somali remitters actually have to the financial system. It is our understanding that remittances do continue to occur, though I understand why people are concerned about the situation. I'm not sure that I would link. And if you ask me, am I concerned that people think that the United States government is taking steps to close these entities out? Of course I'm concerned about it because it's patently false. And I mean, I've written a blog personally, had a blog published to try to dispel some of those notions, and I think it's evident that we in the United States government take this issue very seriously and are working very hard, both with the financial community, with organizations such as Oxfam, and with other governments and with international institutions. But it's a tremendously, as you know, a tremendously complicated issue, and with no really easy apparent solutions. But it's something that we're certainly working on. With respect to the question about asset recovery. So just so we use our terminology, just make sure we get our terminology precise. When we apply sanctions and freeze assets, that is never for asset recovery purposes, because we don't take title to the assets, as has been pointed out before. The idea is that we would be able to lift sanctions at some point, and then whoever the owner of those assets are reverts back to the owner. So we seize and forfeit assets through usually criminal processes in the United States, and in some other countries we'll have civil processes that allow us to do that. And that is a much different and frankly much more traditional type of process by which the government actually takes ownership, takes title to whatever the seized and forfeited assets are, and then you can do the government could do a number of things with those, including in the case of corruption, potentially returning it to the country from which the assets were stolen. The question about beneficial ownership, I think, is somewhat self-evident. Of course, the key to all of this that we're talking about, whether it's corruption, whether it's AML-CFT, whether it's sanctions, is creating a transparent financial system, or creating a more transparent financial system. And one of the key issues associated with that is beneficial ownership, and non-transparent corporate formation practices tend to act against that. I think the United States has been quite clear about our commitment to this issue. President Obama included in his transnational organized crime strategy the need for us in the United States to do better on corporate formation. And as has been pointed out, we have a commitment to do that in the context of the G7. So we certainly recognize that it's an important issue, and we're working very hard to make sure that we can do as well as we can on it.
Great, thanks. We don't have too much time left, so I invite the others to make brief comments on any of the questions that they are interested in.
I don't have much to add to what Danny said, but the questions from Oxfam reminded me of the issue of exemptions. And the Somalia program does have a humanitarian exemption in the resolution, UN resolution. And the regimes I work on have had a history of humanitarian exemption. It's called the kind of basic expenses exemption, where you can apply for an exemption to get certain basic expenses. There's also an extraordinary expenses now. So there is a way to unfreeze funds or make them available. It's perhaps an underutilized process, but the avenue is there. To the question from the gentleman from Canada, obviously beneficial ownership is very important. If someone can just put their assets in their friend's name or in their wives and escape sanctions that way, that's an obvious a way to be able to stop someone from being able to dodge sanctions. As Danny said, another thing I wanted to clarify: sanctions are not meant to be punitive. They're meant to be preventative. So they're meant to freeze the assets, not seize them, so that the person cannot use them for whatever activity you're trying to stop. So I think that's an important distinction, that sanctions are preventative, not punitive or criminal.
Just briefly, I think on the beneficial ownership point, I think it's something that demonstrates where the anti-money laundering rules and the sanctions rules from a compliance perspective are very much hand in glove, because even setting aside the more complicated questions about beneficial ownership, OFAC has its 50% rule that says that if there's a company out there that's 50% or more owned by one or more persons on the OFAC list, that is equally sanctioned, even though it's not listed on the OFAC list. And so it's essential from a sanctions compliance perspective that the diligence that was done for purposes primarily of AML compliance, of finding out the beneficial ownership when that entity was onboarded as a client, that was robust and captured in a way that can then be subsequently used for a sanctions purpose. On the Iran point, maybe just briefly, my four-part typology, I think, was a bit parochial, as I sometimes can slip into being, in not recognizing the EU contribution of the sanctions that went into effect in 2012 with respect to the Iranian oil imports. And I've actually seen some press coverage that talks about the lifting of the Iran sanctions that have been in place since 2012, and I think to myself, haven't they actually been in place since 1995? But I think in terms of what has been most impactful is the multilateralization of those sanctions, which really began to bite with the EU oil import ban in July of 2012, and I wouldn't be surprised if that is one of the first things that is at least the ask to be rolled back, even if that's not the way that it turns out.
Great, thank you. Yes, please.
Hi, Peter Becker. I have a quick question about protection of the person and one's reputation, and this is in connection with the due process remark. In your respective jurisdictions or organizations, is there a mechanism in place whereby you can get your name cleared in a situation where you are investigated, your name appears in an investigative report, but you're not ultimately listed? And I came across a situation recently as counsel to an individual who was targeted, who was investigated. His name appeared in an investigative report. This was in a UN context, and the newspapers picked up on it. And so he did not end up being listed. But if you Google him, you see the investigative report and the news reports in that connection. And we found out that he had no way of redress. That is, he could not go to the Sanctions Committee and ask for a letter clearing his name. So I wonder what it can be done in that situation. It's sort of caught in between. It's not a delisting, but it's sort of a near listing.
Great, thank you very much. Yes, please.
Yes, I have a question regarding due process. What exactly is the standard of proof? Is it preponderance of the evidence, or certainly it must be less than beyond a reasonable doubt, but is it high enough to justify using targeted individual economic sanctions against persons who have been identified by the International Criminal Court as wanted for arrest? I recognize that these are not intended to be criminal, but it would be a lower standard than an actual conviction in the ICC.
Thank you. And we'll take the two questions here, if you could just please keep them brief.
Hello, my name is Maria Georgescu from the George Washington University Law School. I have two questions. I'm interested in your view, how do you justify the imposition of unilateral economic sanctions when they're not imposed under Chapter 7 of the UN Charter? Because I think the UN Charter, Customary International Law, General Principles of Law, provides for rather more friendly cooperation between states and not so much for economic sanctions. And the second question goes to the how should foreign financial institutions, here, for example, European banks, reconcile US law and EU law? Because to my understanding, the EU blocking statute is still in place, and that prevents, to a certain extent, following US sanctions. Thank you.
Thanks. Yes, please.
Hi. My name's Kumar. I work for the Enough Project. We're an organization focused on genocide and crimes against humanity. So my question is about newer sanctions regimes, specifically South Sudan and the Central African Republic, both at the UN and at the US level. And if some of the strategies and tactics which were outlined as being incredibly successful in the AQ context, Iran or Russia, could be applied for these, I guess, lower order but still important sanctions regimes. And in an associated question, I noticed your remark about the absence of the ability to enforce targeted sanctions effectively in other countries around the world. And I'm thinking particularly of the neighborhood I work in, East Africa. Have there been efforts to build capacity beyond AML and CFT, but specifically capacity for sanctions enforcement in those jurisdictions by the US or by other donor countries?
Great, thanks. Let's start at this end of the panel now, and I just want to let the panelists know that we really have about 3 minutes left.
I think I'll actually pass on to others on this one.
Oh, I said 3 minutes. Oh, 3, yeah, 3 minutes.
I'll pass to others.
Okay, I mean, real quick, the standard for our sanctions programs for designation is reasonable cause to suspect. It's been a standard that's been reviewed by our courts at both the trial and appellate level dozens, scores, if not hundreds of times, and has been upheld in every case. So that's the standard, at least in the U.S. With respect to the question on how do we justify the imposition of sanctions when it's not in the UN context, we're a sovereign country, and we certainly have the right to oversee our own financial system. The word extraterritorial has been used on this panel before. While I agree that U.S. sanctions are extraterritorial in their impact, they are in fact not extraterritorial as a legal matter. They apply to U.S. persons, and we, as any country does, have every right to regulate U.S. businesses and to apply restrictions within the limits of our Constitution on U.S. persons. And as I said, our right to do so has been upheld by the courts countless times. With respect to capacity building in East Africa, I think it's a really important point that you raise. I think it's important to give countries, to work with countries and provide them the capacity. We do that in the United States. The Treasury Department has a program to provide technical assistance on these types of issues. And I know that there are, the IMF and the World Bank provide lots of assistance, not necessarily on sanctions in particular, but certainly on AML, CFT. The IMF and the World Bank provide a substantial amount of assistance. And certainly East Africa is a key region that could benefit from it. So it's something that we do try to do.
I'll just add quickly, I'm not aware of the case where someone was cited in an investigation. Usually that, people try to keep that confidential. So I'm not aware of the case. I don't know if Kimberly wants to talk about it. But in terms of East Africa, I think it is a very important point, and they are also parts of the UN, such as UNODC, that do give sanctions help, specific sanctions help. And one of the UN entities, CTITF, has also a project on designations and then implementation of sanctions. So there are resources out there to help countries implement sanctions at the international level as well.
Catherine or David, last word?
Or perhaps I could just add on the blocking statute just to confirm that that is still in place. But if you look at the list of the measures that is annexed to that blocking statute, it is actually quite out of date. So it might be worth just looking at that. But it's true that it's it remains in effect.
Okay. Please join me in thanking the panel.